A federal court has struck down a Jim Crow-era law in North Carolina that imposed criminal penalties on people with a previous felony conviction who vote while they are on parole, probation, or post-release supervision. The judge ruled that the 1877 law was enacted with racially discriminatory intent, violating the 14th Amendment of the U.S. Constitution. The judge said the challenge statute was enacted with discriminatory intent, has not been cleansed of its discriminatory intent, and continues to disproportionately impact Black voters, rejecting North Carolina's arguments that the law was absolved of its racist origins when the state adopted a new state constitution in 1971. The state even conceded that the historical backgrounds from the original enactments of 1877 and 1899 are indefensible, and they do not contest that the law currently impacts African Americans at a higher rate than it does other citizens, which the judge called an extraordinary and telling concession. In addition to finding that the law intentionally discriminates against Black North Carolinians who are significantly more likely to be prosecuted under the law, the judge ruled that the law lacked sufficient standards to protect against inconsistent or discriminatory enforcement by prosecutors. The law is permanently blocked, and state officials have not yet indicated whether they intend to appeal the decision to the 4th U.S. Circuit Court of Appeals. This ruling does not change North Carolina's strict felony disenfranchisement law, which denies the right to vote for people with felony convictions until the completion of their entire sentence, which includes parole, probation, and the payment of all legal fees and fines. This means reenfranchisement in North Carolina is contingent on an individual's ability to pay these costs, a concept sometimes nicknamed pay to vote, and is considered by many to be a modern-day poll tax. This law disenfranchises over 55,000 people in the state, disproportionately Black residents. A state court struck down this felony disenfranchisement law in 2022, ruling that it violates the state constitution, but the North Carolina Supreme Court, with its new conservative majority, reversed that decision and upheld the law. Listen to what Daryl Atkinson, co-director of Forward Justice and a lead attorney in this case, had to say about the law.
Simple. You could have two individuals, two North Carolinians, convicted of the same crime, given the same amount of duration of probation, given the exact same amount of fees, fines, and costs, and the one that has money can buy their voting rights back, and the one who doesn't can't. And in no democracy should the amount of money that you have in your pocket be a determiner of whether you have a civic voice.
Unfortunately, North Carolina is not the only state with this type of restrictive law. Over 4.6 million Americans were disenfranchised because of a felony conviction as of 2022, disproportionately impacting Black and Latino people. Only in Vermont, Maine, and Washington, D.C. are your voting rights never impacted by a felony conviction. Mississippi also has a Jim Crow-era provision that bans voting for life for people convicted of a felony, even after completion of their entire sentence, disenfranchising nearly 11% of its voting population, the highest in the country. A divided panel of judges on the Fifth Circuit struck down this provision, saying that it is a cruel and unusual punishment in violation of the Eighth Amendment. But the full Fifth Circuit agreed to rehear the case and voided that previous decision. A ruling is still pending from the entire Fifth Circuit on this discriminatory policy. In Tennessee, a federal judge recently struck down part of the state's felony disenfranchisement scheme, ruling that the state cannot improperly reject voter registration forms from eligible voters with prior felony convictions and must inform them of their eligibility. According to the lawsuit, Black people make up 16% of the state's total voting age population, but account for 39% of its disenfranchised population. While felony disenfranchisement laws are common, many states are advancing and enacting laws to restore voting rights to people with felony convictions. Minnesota, with its new Democratic trifecta, restored voting rights to over 55,000 people last summer with a new law that restores voting rights immediately upon release from incarceration, as opposed to after parole or probation. A right-wing legal challenge to the law is currently pending before the state Supreme Court. New Mexico also restored voting rights to upwards of 11,000 people who were on parole or probation for a felony conviction as part of the New Mexico Voting Rights Act signed into law last year. Nebraska recently enacted a law restoring voting rights after completion of a sentence, including probation or parole, amending a previous statute that prohibited voting for 2 more years after completing the entire sentence. The bill was enacted into law without the signature of Republican Governor Jim Pillen, who signaled that his office may challenge the law in court. Thanks for watching Democracy Docket. If you want to stay up to date on the latest voting and election news in the courts, make sure to subscribe to our newsletters. You can click the link on the screen or in the description of this video. I'm Sophie, and I'll see you next time.